Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to be discussing basics of the Sunshine Act. Couple preliminaries. If you've attended these webinars before, you know that it's essentially a PowerPoint presentation with me talking in the background. As I'm going through the PowerPoint, you can feel free to ask questions using the chat feature. I would ask, though, that you keep your questions on topic, and we're talking about the Sunshine Act this morning, and that you try and keep them fairly brief. It can be awkward for me to sit here and read several paragraphs that someone has typed out and everyone else patiently waiting. If it appears that your question is unusually complex or specific to your particular situation, we'll do one of two things. We'll either wait until the end of the presentation and I'll come back to it and we can talk about it then for the benefit of everyone. Or I would suggest that we take the conversation offline. You can contact the office either through email or phone, and there are staff members who can walk you through whatever situation that you have. More than happy to help you out. The PowerPoint that I'm using for this video is on our website. And you go to the training tab, you can pick out the PowerPoint along with any of the others that we use, and feel free to use them at your convenience, whether it be for your own personal reference or training purposes or whatever. They're public records, so they're on the website, free for you to use. This session also is being recorded. You should know that the recording is also a public record. And if you would like a copy of the recording, maybe you have a coworker or colleague who wasn't able to attend this morning, reach out to the office as well, and they can provide you with a link to a file sharing program that will give you access to the recording that we produced this morning. Okay, so I think that takes care of all the preliminaries. Looks like we have quite a crowd this morning, so looking forward to a good session. Let's go ahead and jump right into the topic then. And let's talk about why do we have an open meetings law? Sunshine Act, open meetings law, same thing. I always think it's important to begin these webinars with a foundational statement. What is the purpose of this law? And it's interesting in that the Sunshine Act actually has a preamble that kind of describes why the legislature at the time, back in 1956, thought this law is important, and why it was necessary to pass the act. So let me just read this real quick. The right of the public to be present at all meetings of agencies and to witness the deliberation. It's vital to the enhancement and proper functioning of the democratic process, and that secrecy in public affairs undermines the faith of the public in their government and the public's effectiveness in fulfilling its role in a democratic society. Very high-sounding words here that basically come down to the point. It really cuts to the chase here, that government has an obligation to function in sunlight rather than conducting business in secret. Yeah, I really can't say more. I'm trying to think how to explain this further, and I think that the preamble really covers it. And even today, the courts and the legislature still regard this as a very important aspect. And while we don't have a lot of case law regarding the Sunshine Act, we are seeing greater activity. And if anything, I'd say for the last two sessions of the Pennsylvania legislature, they've been fairly active with the Sunshine Act. I mean, they passed an amendment. There's a couple ideas floating around for further amendments and so forth. And it just seems that recently the Sunshine Act is getting greater and greater attention. And I think as public employees and public officials in particular, We need to pay greater attention to what the Sunshine Act requires. And the citizenry, residents, taxpayers, individuals, are all becoming more and more aware of the fact that, number one, the Sunshine Act is out there, and number two, the rights that it gives them in attending meetings. So I like to break it down in, from our perspective, there are three big factors or three big components of the Sunshine Act that government in particular needs to be aware of. First, there's a requirement that all public meetings have advance notice and that they explain to the public, how do you attend this meeting? Then there's the right to observe those deliberations, taken right out of the preamble. And then third, the public has a right to comment on any official action prior to the decision to take that official action. Okay, so let's keep those three main factors in mind here as we progress through the presentation. And as we jump around a little bit, you'll see how these three different factors interact and how important they are. Okay, first offhand, who is covered by the Sunshine Act? Well, the law says any state or local government body and all committees. Notice I have committees italicized here because that's an important factor. The question often comes up, is our committee covered by the Sunshine Act? Do we need to open it up? So whenever you're researching a law, I recommend that you take a look at the definition section, because the definition section oftentimes fills in those blanks. Or if the law itself, if the language appears to be vague or somewhat confusing, oftentimes the definition section will provide the necessary clarity. So, looking at the law itself, any state or local government body and all committees that perform an essential government function. Okay, what is that? Well, it's a somewhat subjective phrase, but let me throw out an example here. Let's say that the local girls softball team has won the state championship, and the township has decided we need to recognize this. So we're going to have a parade and, maybe some sort of public recognition ceremony, a cookout or whatever that, recognizes this, really big accomplishment that the girls have completed. So they appoint a committee that's going to organize the parade and the public ceremony and the cookout and everything. Okay. It's a big deal for the township. Okay. But can we say that it's an essential government function? Probably not. As important as it is, there is no requirement that such a recognition ceremony or parade take place. And government can progress, it can survive without having said recognition ceremonies. So to say that it is an essential government function would probably be a stretch. But let's change the example and say that there is a standing committee appointed by the township to periodically review all ordinances, laws, resolutions, and so forth to make sure that the language is up to date, that the ordinances themselves are relevant and aren't in conflict with any state or federal statutes, et cetera, et cetera. Would that be an essential government function? I think you could argue that it is. So in the first example, the softball team recognition, chances are you could not make a cogent argument that their meetings should be open to the public and covered by the Sunshine Act. Second one, you probably could, okay? Essential government function. Okay, then we come up to the next one. Exercises authority to take official action. Okay, what's official action? Again, look at the definition section, and they'll provide you with an explanation as to what official action is. And within that definition, it includes the term making recommendations, which I think is important when we're considering whether a committee meeting would be open to the Sunshine Act. Is this committee making recommendations to the elected board? If it is, then I think you could say that in fact this this committee should be subject to the Sunshine Act. All right, but then we can go one step further. This is what the law says, but what about case law? And like I said, there isn't a lot of case law on the Sunshine Act, but what is out there, I think, is instructive. And this particular case is Ristal versus Casey. And the Casey is a Governor Robert Casey from several years back. And it deals with this issue of a committee that had been appointed, and someone sued asking if, in fact, this committee should be subject to the Sunshine Act and the public allowed to attend. This is what the court said. They kind of broke it down into several factors. These factors build upon each other. So let's take a look at what that says. The first thing that the court asked is, does the committee have decision-making authority? Now you're thinking, well, what committee wouldn't have? But yet there are committees that are appointed, given various situations where maybe it's just for information gathering. Okay, we want you to go out and find out what's going on in this particular topic and report back. We don't necessarily want a recommendation, or we don't want a decision made, but we just want you to provide information for us so that we are educated on the subject. Okay, and then we'll take it from there. And, unfortunately, the realities of politics are that occasionally a committee is appointed just to make a topic go away. All right, it's some contentious issue, but maybe not necessarily that important. A decision can wait. So what do? Well, you appoint a committee. And, if you never hear from the committee again, that's okay. All right. No decision-making authority. You just say, we're going to give it to a committee and we'll see what they come up with. All right. Then the next thing, are members appointed by the board and are they authorized to act on its behalf? Okay. You want that nexus between the elected board and the members of the committee. And this brings up a particular topic. There is a misunderstanding that public officials, citizens think that in order for a committee to be covered by Sunshine, there needs to be a quorum of elected officials on the committee, and that is inaccurate. You can have a committee covered by Sunshine where there are actually no elected officials. It's dependent on whether the factors that we're talking about are met. So let me repeat that. You can have a committee where there are no elected officials on it, and if they meet the factors that we're talking about, they are covered by the Sunshine Act. There's no requirement that any elected official be on the committee, much less a quorum of those elected officials. Okay, so are the members appointed by the board and are they authorized to act on its behalf? Well, you're thinking, what committee wouldn't be appointed by the board? Well, you can have committees that are self-perpetuating, where they're initially appointed by a board, and even though the makeup of the board may change every election cycle, the committee makeup doesn't change for whatever reason. And if there is a vacancy on the committee, the other committee members are the ones responsible for filling the vacancy. Okay, and there is no control exercised by the elected official over the makeup of the board. It's what we call self-perpetuating. They are out there, and obviously they would fall outside the parameters of this particular requirement as described by the court in this decision. Okay, and then here's an important one that I think this really cuts to the chase. Are the recommendations from the committee to the elected officials pursuant to statute, ordinance, or regulatory authority, whereby the result is the enactment of a law, policy, or regulation? All right, now think about how that would work. Because if we go back to our example of the softball team, you're not going to find any statute or ordinance that says if the girls softball team wins the state championship, you must have a parade and a recognition ceremony, okay? Nothing of that committee's mission or task is grounded in law. Whereas there are laws saying that you will keep your statutes up to date, they will be relevant, they will not conflict with other statutes or laws and the like, okay? And then if the result is the enactment of a law or ordinance or policy, then that also cuts to the quick in determining that, yes, the deliberations of this committee should clearly be covered by the Sunshine Act. Note, you are making a recommendation back to the elected body, so you can see how the language and the definition of the law corresponds to the language used by the court to determine whether or not the deliberations of this committee should be open to the public. Now, all that being said, using the law, using Ristal versus Casey, there still may be instances where it's unclear as to whether the deliberations of this committee should be sunshined or not. When that occurs, our recommendation is lean towards transparency. Now, obviously, we're the Office of Open Records. We're more of a state transparency office, so we're going to say that. But looking at it from an elected official's perspective, there is a very pragmatic perspective to this. Yes, opening up your meetings might be inconvenient because you're going to have postings, you're going to have the public present, they're going to be asking questions, so forth and so on, okay? You prefer not to, but this is what the law says. Now, if you choose not to, you run the risk of having a complaint filed, and then you have to pass what I call the straight face test, meaning, can you stand before a judge and explain why you didn't open your meeting to the public and do it with a straight face? If not, there's a good chance the judge is going to find against you and you could be facing sanctions. Those sanctions can be painful. All right, so you weigh that versus the inconvenience of not opening your meeting. And yes, from a practical perspective, I would recommend lean towards transparency, and when in doubt, open up your meeting to the public and follow the requirements of the Sunshine Act. Okay, then we need to answer the question, is it really even a meeting? Okay, well, there needs to be a quorum. And like I said, it's not a quorum of elected officials. It is a quorum of the committee. And, you know, I should say, obviously, if it is a meeting of the elected officials of the board, then you have to have a quorum present. If there isn't a quorum, then you can't, conduct business because you don't have a majority in order to, take any official action. Now, what about members phoning in? Okay, this even goes to, pre-COVID, okay? Members can phone in order to reach a quorum. The requirement is that the technology needs to be firsthand, meaning that everyone needs to be able to hear the member phoning in, and the member phoning in needs to be able to hear everybody else. What you can't have is someone sitting in the conference room with a cell phone up to their ear, relaying back and forth as a middleman. That is unacceptable. But, having a conference call speaker or, one of the online platforms like Zoom or Teams or Skype, something like that, that usually is acceptable. The exceptions to the phoning in are for boroughs. The Pennsylvania Borough Code requires that a quorum be physically present, and then anyone above the quorum can phone in. And the same requirement exists for first-class townships. Okay, they require that all of the commissioners or that a quorum of commissioners be physically present, and then anyone in addition to the quorum can then phone in. And like I said, it's that same requirement that they need to be able to hear everybody and vice versa. Then we need to answer the question, is there deliberation? Well, deliberation, again, go to the definition section, any discussion that could lead to a decision. There doesn't necessarily have to be a decision. I mean, the decision could be not to do anything. But if that discussion ultimately could lead to a decision, then that's considered deliberation, and you have to open up the gathering to the public. Is there decision making? Well, decision making is official action, which is memorialized in the form of a vote. So if there's any sort of vote taking place, obviously that's decision making. We will occasionally get calls from a member of the public. Hey, I saw two of the township supervisors, and three-member board, having breakfast the other day. Is that against the law? Well, no, it's not. You can have a quorum of a board gather as long as they're not discussing agency business, whether it be township, city, borough, school board, authority, whatever. Okay, they can meet for breakfast, talk about their families, talk about the weather, whatever. They just can't talk about township business or borough business or whatever, okay, because that would be outside the parameters of the Sunshine Act in its deliberation, okay, which would be a potential violation. And then finally, I want to stress, beware of email meetings, okay? This oftentimes happens at beginning of the calendar year where you've got a new board seated, maybe the chairperson, newly elected, came in from a business background. And you know what? At work, we get everything done with email. It's very efficient. It's quick. We need a fast decision. So let's just handle it by email. Well, obviously, based on these other parameters that we've talked about, that would be a violation. You're deliberating outside the public eye. And while those emails might very well be accessible under the right to know law, the Sunshine Act requires that deliberation take place in a public setting. Now, let me distinguish, though, between policy level decisions and administrative level decisions. You can have emails in order to resolve certain administrative things. Let's say that at the last monthly meeting, the board took official action to spend $300,000 on street repairs in the borough. Okay, that's going to be our budget. Public Works came to us and said, this is how much money we have. We think that will allow us to pave X number of blocks within the borough. Do you approve? The board votes, and yeah, we're going to spend $300,000. Okay, but then Public Works comes back and asks, which blocks would you like us to pave? Okay, that discussion is administrative in nature. The official action has already taken place. The board has approved the resolution to spend the $300,000. How you choose to spend it now becomes an administrative issue that you can resolve through email and non-public meetings. Or, Public Works would take care of that as a matter of policy. It just depends on how your administrative requirements are set up. But you need to distinguish between issues that are administrative versus issues that are policy, and allow common sense and the law to help you in determining where that line falls. Do not try to outthink it. Do not try to subvert the purpose of the Sunshine Act by claiming that an obviously policy level issue is administrative in nature, because ultimately you'll get called out on it. And remember what I said about Okay, what is not a meeting? Well, like I just finished talking about, administrative action versus agency business. Work sessions, okay? Um, a work session, I think school boards are probably the best example to use here, where um, every month the school board has a business meeting that is open to the public and where they take official action. But then every other week, they also have a work session. It's not advertised to the public, it's not open to the public, but the full board is present, and it's primarily for educational purposes, meaning that the superintendent, the assistant superintendents, principals, staff members, and the like make presentations to the board to update them on the progress of various initiatives, various projects that the board has already undertaken or is considering, so that the board is educated on these matters so that when it comes time for the monthly business meeting, they can make an informed decision. The communication is primarily one way. It's presentations by staff members. Individual board members can ask questions of the staff members. What they cannot do, what they cannot do is discuss the merits of the presentations among themselves. Okay, because that would be deliberation, and that must take place in a public setting. So there's no deliberation, and obviously there would be no decision making. Now, a word of caution here. We have found, well, first offhand, we found there are some boards that have what they call a committee of the whole, where the board gets together and they deliberate, but they say, well, this is a committee, it's not the full board. Okay, probably a violation there, and you want to be very careful about that. It has the smell of trying to outthink the Sunshine Act in order to get around its requirements, and you're probably going to get in trouble. The other situation that we find periodically is where the board calls it a work session, but they advertise it, they still allow the public to come, they allow public comment, and occasionally they will take votes. But then why do they call it a work session, which creates the expectation that there's not going to be any deliberation, there's not going to be any votes? Okay, you've met all the legal requirements of the Sunshine Act, but you're violating the spirit of the act by calling it a work session and not a public meeting. Okay, and looking at this devil's advocate sort of thing, if I wanted to get a vote through the board without a lot of public backlash, I'd call it a work session, create the expectation that there's not going to be a vote, even though I've met all the requirements of the Sunshine Act. All right. I'm not sure how a judge, upon hearing all of this, would react favorably. And again, we'll talk about sanctions when we get towards the end of the presentation. They can be pretty painful. Okay, so you want to be careful about how you handle these work sessions. Now, the greater majority of boards are fully compliant with the Sunshine Act. And I'm only saying this because they represent the extreme ends of the continuum, where a small minority of boards have gotten themselves in trouble. Okay, but I think it's just helpful, because that's the purpose of the webinars training, okay, to make sure that you don't go there. All right, but I don't want to create the impression that everybody's doing it and everybody's going to get in trouble. All right, but that's why we bring this out. Let me get a quick sip of water here. Next slide. Okay, let's talk about the public notice requirements, the first leg of the three-legged stool here. Okay, under the Sunshine Act, you're required to provide 3 days advance notice of the first regular meeting of the year, and then you would include all of the dates for the remaining meetings of the year. But to break that down, essentially what it's saying is you have to give at least 3 days notice of any regular public meeting. Okay, now, and usually what happens is that at the beginning of the year, you have an organizational meeting. Okay, so 3 days in advance of that, you put the legal notice in the paper that we're having the organizational meeting. And let's say, historically you've met on the first Tuesday of the month, so you would put down those dates for the remainder of the year, and you've met your legal requirements for the dates. Now, if by chance, once you have the organizational meeting, and it's decided, well, we've got too many conflicts here, we need to change. Let's say it's going to be the third Tuesday of the month. Well, that would require then a second legal notice at least 3 days in advance of the next meeting, that we're now going to have our meetings on the third Tuesday of the month, and here are the dates for the rest of the year. All right. It needs to be in a paid newspaper of general circulation. Newspaper articles don't count. It needs to be a legal notice. Websites don't count. Now, if you do have a website, and if you are posting when your public meetings are on the website or Facebook pages or whatever, that's great. And please don't stop doing that, okay? However, you must still have the legal notice in a paid newspaper of general circulation for the municipality. Those free sales circulars that show up in our mailboxes 2 or 3 times a week, it seems, they don't count either. Law says paid newspaper of general circulation. It doesn't say websites. Now, I realize that this is somewhat problematic given structural changes we're seeing here with the media industry. And the legislature is aware of that. But until they take action to amend the Sunshine Act, this is what the law says, and we must comply with it. And by the way, these notices also need to be posted at the meeting site at least 3 days in advance. Now, what about special meetings? What about where an item has come up for business and we can't wait until next month? It needs to be taken care of sooner than that. Well, the Sunshine Act recognizes this, and it allows you to have special meetings. This would be a public meeting where you've got a quorum of the board present in order to deliberate and take official action. In those instances, all the requirements remain the same, but the time frame is reduced now from 3 days to 1 day. Obviously, given the structural changes that we are seeing in the media industry, you're going to have to also take into consideration how fast or how long is it going to take the newspaper to get it published. It needs to be a minimum of 24 hours in advance of the actual meeting. And then you have what are known as emergency meetings. And this is where you've got an item that has come up that simply cannot wait. You've got to make the decision now. The example I use is the snowplow, okay, where small borough, we've got one snowplow and it's on its last legs, and it just broke down. It's so old we can't get parts for it to repair it. And the forecast is saying there's a storm on the way and it's going to dump a couple feet. We really need a snowplow, and we need one now. Okay, so it turns out that down the road, there's a dealer that has a snowplow available. We can go buy it. Okay, so we need to have a meeting to approve that purchase. Clearly, emergency circumstances, and it justifies having a gathering of the board outside of the public eye. Okay. The only caution is that do not attempt to outthink the Sunshine Act by having an emergency meeting where you have created your own emergency. All right, again, straight face test. Can you explain to a judge why you had a meeting outside of the public eye that you called an emergency when looking at the facts? Maybe not. It's the decision you've got to make It's the risk you've got to take when you're having an emergency meeting. 9 times out of 10, probably better odds than that. Yeah, it's a justified emergency. So you're going to have this meeting without the public being present. But if not, if you're stretching the law a little bit, chances are you're going to get called out on it, and it's going to be painful. Now, what if we have a public meeting scheduled, but we need to cancel it? You know, someone got sick, we can't have a quorum, someone's out of town on vacation, or maybe there just isn't anything, you know, really pressing this month. So we're going to skip if the law allows you to do that. All right. Well, there's nothing in the Sunshine Act that requires you to post a cancellation, but still, I would suggest use your social media tools to get the word out that you're canceling a meeting, because nothing upsets the public more than to show up at the township building or borough hall or whatever. Lights are out, the doors are locked, and all you hear are crickets chirping. Okay. And then they call up the next day and it's like, oh, well, we canceled. We couldn't get a quorum together or whatever. Let the public know what's going on so that they aren't wasting their time and everybody's satisfied, as to what's going on. All right, agendas. This is a fairly recent addition, was passed last August 29th, in fact, that the legislature passed this and the governor signed it into law. And it is what it does essentially is require that all agencies, number one, you must have an agenda, and that agenda must be posted at least 24 hours in advance of the public meeting. And that agenda must detail all matters to be deliberated on and/or planned official action that would take place at the public meeting. Now, people ask, how detailed do we need to be? And while the law is silent on this, I would take a common sense approach, thinking that if I am a resident and I'm not necessarily familiar with this topic, put enough explanation in that, that an uneducated resident would have a reasonable understanding of what the board plans to deliberate on or talk about. Okay, question has come up. What is meant by posting? Well, in this instance, it's at the end of the slide, so you're a little bit ahead of me. I'll get to it. Good question, though. Okay, this agenda requirement exists for regular or special meetings. Obviously, you more than likely wouldn't have an agenda for an emergency meeting. And it wouldn't include work sessions or those gatherings where there will not be any deliberation or decision making, like the work sessions that I described earlier. And executive sessions. There's no agenda requirement for executive sessions, and I'll explain executive sessions here in a little bit. Okay, now the posting requirements for agendas. The law says websites, okay, but we've noticed a trend where many municipalities are migrating from having a website to using other social media platforms as their main way of communicating with their public. If you're using a Facebook page and you don't have a website, then the Facebook page should have the agenda posted. Okay, if you have both, ideally you would post to both, but the law says website. Okay, then you must have a copy of the agenda also posted at the agency offices, at the meeting site, and then you have to have copies available for the public at the meeting itself. So you would have these agendas available. Okay, so that's how that works. For the posting at the agency offices, is there any guidance on exactly what this requires? Well, yeah, if you, there is no guidance per se in the Sunshine Act, but I think following precedent with other laws and common practices, you could, post it on the front door. You could post it, on a bulletin board. Most government offices have bulletin boards available. As long as you meet that requirement so that if the public comes into your office, they can readily see what the agenda is for the next public meeting. Okay. All right. Agendas continued. Again, looking at this new provision to the law. If you want to change the agenda, okay, the law specifies how you can go about doing that. And we'll take a look at, okay, we use corkboard on a tripod right outside of the elevator. Hey, looks good to me, or sounds good to me. Okay, back to changing the agenda. There is a timeline that I think would be helpful for us to take a look at. Okay, and it's based on this 24-hour requirement. Anything prior to 24 hours before the public meeting is fair game. You need to change the agenda, change it as required or as your needs dictate. Once you hit the 24-hour threshold, you can only change the agenda for items that are de minimis in nature. There's no expenditure of funds as a result of the agenda item, and there would be no entering into any contracts as a result of the agenda items. Okay, if those two requirements aren't met, then you're okay with the changes that you make, provided it's still de minimis in nature. And that's, legal talk for meaning nothing important. All right, to paraphrase. So then we come up to the meeting itself. The meeting is called to order. Things change. Now the requirement is that you can change the agenda, but it needs to be by majority vote of the board. So let's say we have our agenda, the meeting is called to order, and something new comes up. Maybe, through public comment or a board member brings this up, and there is consensus that yes, we need to act on this. So looking at this from a practical perspective, number one, there needs to be a vote. I move, we change the agenda. Okay, second, all in favor, aye. Okay, and because that becomes official action, it's memorialized in the minutes of the public meeting. Okay, so that's your first vote that must take place just to discuss whatever the new topic is. Then typically there would be a vote on whatever that new topic is. Now, maybe not, but because you are deliberating on this item, that's a requirement of the Sunshine Act. It's also a requirement of the agenda provisions. So you need to take a vote to add this item to the agenda. And that vote needs to be fully explained to the public. Why are we doing this? Well, it's so we can discuss this topic. Okay, so that needs to be announced during the meeting, and it gets memorialized in the minutes of the meeting. Now, if the agenda is changed due to going through this exercise, within 24 hours after the meeting has adjourned, the amended agenda needs to be posted, and the changes need to be reflected in the minutes wherever they are kept. So the posting requirement for the agenda prior to the meeting was website, Facebook page, meeting site, business office. Okay. Even though the law is silent on this, the reasonable conclusion is that the amended agenda gets posted to the same places. Then the question comes up, well, how long do we need to keep the amended agenda posted? The law, again, is silent on that, but this is George's recommendation. A judge may disagree with George at some point if this matter is ever litigated, but George's recommendation is that since there's a 24-hour requirement before the meeting for agendas, let's put a 24-hour requirement after the meeting for agendas, that the amended agenda needs to be posted for 24 hours and then it can be taken down. All right. Again, no legal basis for saying that, no case law to verify that, but this is just George's recommendation, 24 hours. Go for it. And if a judge disagrees, let me know. Okay. Moving on, the second leg of the stool, public comment. Okay. Commenters can be limited to residents and taxpayers. Okay. If we go back to the law says during a public meeting, prior to any decision being made, the public can comment. Okay. But the board can limit comment to residents and taxpayers. The board can require that you sign in order to make public comment. What they cannot do, and this is based on a federal court decision recently, they cannot require you to give your home address in public. Okay, they can require you to give your address by signing in, but they can't require you to stand up and give it based on your constitutional right to privacy. All right, questions come up. If the committee meeting must be sunshine, does there need to be public comment? Our position on this is yes. Okay, here at the Office of Open Records. This is an issue that has not been litigated, and there are some organizations that disagree with this based on some wordsmithing with what the Sunshine Act says. Okay, full disclosure. Office of Open Records believes that if the meeting is open to the public, then they have a right to comment. Okay, there are some organizations that disagree with that conclusion. I'm not going to go into their legal reasoning, but I just think it's fair to say that until the issue is litigated, I cannot provide you with a definitive answer, only that it's our position here at the Office of Open Records that the answer is yes. Okay. Okay, back to public comment. Well, back to the slide. Okay, so the law says that the resident or taxpayer has a right to comment on issues that are or may be before the board before any pertinent vote. Okay, what's problematic is the inclusion of that word may be before the board, okay, because that kind of opens it up. It becomes subjective. It may not be on the agenda, but someone wants to comment on just how horrendous the potholes are on their street. Okay, and the board has heard this all before, but based on the inclusion of that word may, the public has a right to comment on anything that comes to mind. Okay, so how do we deal with that? Well, let me get to that here. The board may establish reasonable rules for public comment. Usually that's interpreted as time limits. Okay, we're going to limit everyone's public comment to 3 minutes. Or let's say that there's a really hot button issue. The meeting is packed and a lot of people have come in wearing the same t-shirts and they're all signed up for public comment. Well, I think it's reasonable to assume you're going to be hearing a lot of the same stuff. So there's absolutely nothing preventing the president of the board approaching this group and saying, hey, would you mind appointing a spokesperson? And, we'll give that person, maybe 10 minutes to speak to make sure that everybody's concerns get covered. But that way we won't be here all night. We won't be hearing the same thing over and over. Your concerns will be heard by the board. What do you say? Do you agree to it? And, there's a good chance that they will. Maybe they won't, but maybe they will. Okay. Absolutely nothing wrong with doing that. If it's a matter of policy or even statute ordinance that in order to run your meetings, you allow a 3-minute comment period, well, you can set the rules aside and maybe allow everyone a 5-minute comment period for just this meeting. All right. Legally, there are ways around this where you can manage your public comment using reasonable rules and be in compliance with the Sunshine Act. Okay. All right. Oh boy, long one here. When someone comments during the hearing of visitors, we ask them to say their name and address. We also include their name and address in the meeting minutes with their comment. Does the right to privacy continue in the meeting minutes, or should we leave the addresses out of the minutes? That's a very good question. Well, first offhand, the fact that you are requiring someone to give their address publicly could be a problem. You know, if they object to it, there is a legal basis in case law that supports their objection. Okay, so I'd consider maybe removing that. Putting their address in the meeting minutes, you know, it certainly isn't a requirement that you do so. I would lean against it, just as a matter of practice. But, you know, for all practical purposes, if I want to find out someone's home address, there are easy ways to do it. Okay, usually Googling it will simply bring that home address up. I think I would lean against it, but again, case law only covers a verbal requirement, you know, that I stand up and give my home address. It's really up to you as to what you want to do related to the meeting minutes. Yeah, and I'll leave it at that. My recommendation would be consult with your solicitor and rely on their legal guidance and advice as the best course of action as to how to deal with that. Okay, that's what I would do, I think, or that's my recommendation. I think that's probably the best course of action. Okay, now getting back to this word may for the topic of comments. This is what we consider a best practice. It was brought to our attention by a number of municipalities that have adopted this. It is not based on law. They actually have 2 comment periods. The first comment period is limited to the matter at hand, meaning that, okay, we've had a motion, a second, now we're going to have public comment. Public comment is limited to the matter on the agenda that we're getting ready to vote on. Okay, that's the first comment period. Then they have a second comment period, usually at the end of the night, where we open it up to whatever a resident or taxpayer wants to talk about. That's when you get the pothole discussions and the like, okay? It works for them. It's consistent with the requirements of the Sunshine Act, and everybody is happy, okay? What you don't want to get into is being too stringent with limiting what a person can talk about during public comment, even though it is related to the agenda at hand. Okay, there was, you know, a situation last year where there was a school board that was going through some contentious issues, and people would you know, they'd have their public comment, and if they used certain words, or if they failed to use certain words, the solicitor who was present at the public meeting would say, and paraphrasing, in effect, that your public comments are basically off topic. They're irrelevant. And as a result, we are cutting you off. You're not allowed to have any further public comment. You know, they use the term, you're done. Okay, that resulted in a federal lawsuit where the court determined, or the court agreed, at least in the initial ruling, I'm not sure where it stands as far as any appeals go, that yes, you are violating the public's right to free speech by cutting them off during their public comment, by claiming that the comments are irrelevant because you're using words that are not consistent with what we're using as a board. Okay, be careful about stuff like that. Be careful about editing your comments. Be careful about editing any videos. Be careful about cutting off the public during public comment, simply because you may not like what they're saying, or you may not like the way they are saying it, okay, based on federal case law. Okay, but going back to the specific versus general comment periods, that's proved workable. We think it's a good idea, but there is no legal requirement that you follow through on it. Just maybe something to consider, maybe something to talk about. Okay, executive sessions. Executive sessions are gatherings of the board outside of the public eye where you are discussing sensitive issues. The Sunshine Act allows you to do this. Okay, executive sessions can be held before, during, or after an open meeting, or they can be announced during an open meeting for some future time. You know, the chairman of the board will stand up and say, we held an executive session and this is what we discussed, or we're going to have an executive session tomorrow night and this is what we're going to be discussing. This comes up to the second criteria. You must give a complete reason for why you are having the executive session. What you cannot do is simply say we're meeting for personnel reasons. And this goes back to a legal decision, the City of Reading versus the Reading Eagle, which was the local newspaper. Again, further case law where the court said you must give sufficient explanation so that the public is satisfied you're a meeting outside of the public eye for a justifiable reason. Okay, a couple questions have popped up here based on the previous slide. For items on the agenda, our board makes a motion and a second before asking for comments. Should it be asking for comments prior to any motion? Terry, that's up to you, okay? As long as it's before the actual vote is taken, I think you're on solid footing. Okay, next one has popped up. What about a person making public comment where the person is speaking negatively about an employee? Can their comments be cut off? It's going to really depend on what they specifically say. And I would exercise a lot of caution here. If they become abusive, okay, meaning their language, maybe possible libelous comments and so forth, yeah, it's possible you can cut them off. But there is case law going back to the 1950s. I forget what it says, but it basically says, public comment does not need to be respectful. Okay, it can be contentious. It can be argumentative. You can call out your public officials when you disagree with them. And, we have a history in our democratic society of not always being polite. So, be very careful about where you think that line is and when you think people are crossing it. Does that mean you have to sit there and take anything that's said? No, but I think you get the gist of what I'm saying here. Okay, good question. I wish I could tell you exactly where that line is, but case law supports very contentious discourse between the public and their government. Okay, it does not have to be pretty. That's a great question. We could talk about that for hours, but we don't have hours. Good question now. Okay, back to what we're talking about, executive session. There's no requirement that you have minutes for an executive session. And if you do, those minutes are exempt from disclosure under the right to know law. No official action can be taken during an executive session. Now you can poll board members saying, well, what do you think? How do you think we should proceed? Okay, but you cannot take an actual vote. The vote must be taken during public session. So let's say you meet for executive session to investigate and determine whether or not an employee should be disciplined because they screwed up, they did something bad. All right, so you hear everybody out, you poll the board. Well, what do you think? Should we suspend this employee? And yeah, you kind of agree. This is what we need to do. Okay, so you adjourn the executive session, you reconvene the public session, and then you need to take a vote, even though it may not be on the agenda. Okay, that's acceptable. Okay, so you make a motion, second, take the vote that we are going to suspend this employee for, whatever, 3 business days for disciplinary reasons. Okay, you've done it the appropriate way. If you fail to take a vote in public session, you are potentially in violation of the Sunshine Act. because you're misusing an executive session. Okay. Now, talking about misusing executive session, the Sunshine Act details the reasons for why you can go into executive session. Personnel matters such as hiring, firing, discipline. The personnel matters must relate to a specific individual or a specific position, like a vacancy. You cannot discuss general personnel policy in executive session. You can discuss labor negotiations, and labor strategy. Obviously, you would not give your negotiating strategy in a public session. Considering the purchasing, leasing, or selling of real property. Okay, now the Sunshine Act does not say selling, but there is an unpublished Commonwealth Court decision that reasons you can discuss the selling of property in executive session outside of the public eye. Consulting with counsel, meaning your solicitor, about litigation. Okay. Avoiding violating privilege or confidentiality. Again, this would involve your solicitor, where any discussion with your solicitor on sensitive matters is covered by attorney-client privilege. Okay, so that to discuss that privilege in a public setting would be violating privilege, so you can meet in executive session to have those discussions with your solicitor. Discussing university admission standards. I don't know. I guess this was an important issue when they came up with the Sunshine Act back in the 1950s. And then discussing emergency preparedness, such as homeland security issues, maybe evacuation plans, emergency response plans, and the like. Okay, you can discuss those with your emergency management administrator, whomever, in executive session. Okay, moving on. Violations, okay, of the Sunshine Act. Now, during a public meeting, any member of the public can object to a perceived violation anytime during the meeting, and they would not be considered out of order. They can respectfully stand up and say, "Excuse me, Mr. Chairman, I believe you're violating the Sunshine Act because." All right, and the chairman then, he can consider it and say, "You know what? I think you're right. We forgot to vote on this particular issue that we discussed in executive session. We're going to have the vote now." Okay. The agency can cure the alleged violation at any time. Okay. The act allows that. But let's say the chairman thinks about it and says, "No, I don't think we are violating the Sunshine Act." Well, the public can then file a complaint, and they do that through seeking legal recourse with the court within 30 days of the alleged violation. They seek legal relief. So if it's a local agency, they would go to their county court of common pleas. And it could be, a declaratory judgment, it could be an injunction, whatever's appropriate as a remedy for the perceived violation. So they go to court, file the complaint, and then usually the judge will hold a hearing and hear both parties out. And that's where you come up against this straight face test that I mentioned earlier, because the agency will need to defend its actions in court. Now, the judge could find in the agency's favor, yes, I agree, there was no violation of the act. Okay, but if they disagree and say this is a violation, they have great latitude in what sort of sanction they can impose on the agency. It could be just a slap of the wrist. Yes, it is a violation. Don't do it again. Or they could void a vote. They could void an entire meeting. We've seen that happen. Or if it is particularly egregious, they could levy fines. And it's up to $1,000 for the first violation, $2,000 for the second violation, and so on. The fines are not paid by the agency. The fines are paid by the board members. It comes out of your pocket. So reach for your wallet, reach for your checkbook, because if you're going to get slapped with a fine. And honestly, I don't know how many of you have sat through Commonwealth Court, or I'm sorry, sat through a common pleas court, but you catch a judge on a bad day, who knows what's going to happen. Fortunately, there haven't been a lot of fines, but when they are imposed, okay, it can be painful. Yeah, we'll just leave it at that. Okay, then coming up on some miscellaneous issues that you need to be aware of when it comes. The Act requires that you must produce minutes that record attendance, what members of the board were present, voted, and how they voted. Now, if it's just a standard up or down vote, did the motion pass or was the motion defeated? But if there is a roll call vote, each individual board member's vote must be recorded in the minutes. The public can record a meeting, and they don't have to announce that they are doing so. I can, for instance, take my cell phone, set it on record, put it in my pocket, and I don't have to tell anyone that I'm doing it. It is not a violation of the Sunshine Act. It's not a violation of the Pennsylvania wiretap law. What I recommend is at the beginning of the meeting, when it's called to order and the chairman is making the necessary announcements, also include in there a comment, by the way, there's no expectation of privacy during these meetings, and it may be being recorded by any member of the public, okay? And that takes care of it. If by chance the agency is recording its own meeting, those recordings are considered a public record, discoverable under the right to know law, and the minutes that result from that recording are also considered a public record, discoverable under the Pennsylvania right to know law. Okay, so you can record meetings without telling anybody, and there's nothing that the agency can do about it. All right, so we are at the end of the presentation. Some really good questions today, and I noticed the attendance is a little higher than we've had in the past couple months. I think that's great. If you have any further questions, now's the time to get them in before we sign off, or reach out to the office. The website address and emails are on the screen right now. Okay, questions popped up. Does a public meeting need to accommodate the physical presence of the public? Good question. Yes, it does. Okay. During the 2020 COVID emergency, when there was an actual state of emergency, I think it was called Act 15, allowed agencies to go to strictly virtual meetings, okay, without a public component or public presence component. That emergency declaration, however, has lapsed. So we are back to what existed prior to the emergency declaration. And we look to the Sunshine Act, we look to the legislature and their commentary, and it clearly implies that there must be a public component to any public meeting. You can have what are called hybrid meetings where you stream, okay, using Skype, Teams, Zoom, whatever, but you must still accommodate a public physical presence. Now, if your meeting room only allows 10 people, then you would have, usually what happens is you would have an overflow room or some sort of public accommodation to allow further public participation, okay? But clearly, and I've been to public hearings of the legislature where they have made it quite clear that there is an expectation of the public being able to have face-to-face discourse with their public officials. I know, if we have a return to any sort of emergency declaration, we'll go back to the idea of just live streaming. But until that happens, there is that expectation of a physical presence available for the public. Hopefully that addresses what you're saying there. Okay. Any more questions? Get them in the hopper, get them up on the screen as soon as you can. In the meantime, I'm going to direct you to our website, which is an excellent resource. For the Sunshine Act, there's a page with FAQs, the law itself, and some pointers and stuff that you can look to. The website overall, great resource for the Sunshine Act and the right to know law, legal opinions, decisions rendered by the Office of Open Records, guidebooks for the public, guidebooks for agencies, training resources, recorded webinars, and the like. Feel free to take a look. If you have any further questions, contact the office, and they bend over backwards to help you out, get you pointed in the right direction where you need to be headed as soon as they possibly can. Okay, they realize that if you're contacting us, number one, it's important, and number two, it's time sensitive. So they try and help you out as best they can, barring giving you actual legal advice. Okay, that's between you and your solicitor. Okay, so I want to thank you for your participation today. Again, very good questions. It's refreshing to see public officials on top of their game here with, learning about this law and applying it as to how you can best serve the public. So I want to thank you. We'll be back out here again in 2 weeks with another webinar. In the meantime, stay cool, stay safe, and hopefully we'll see you again. I'm going to sign off now. Take care.